Now that I'm done a lot of my media appearances involving the Supreme Court's end of term, including on Fox News and the Lars Larson Show and beyond, I want to talk about some of the cases that have been coming down the pike that I haven't had a chance to report on. And I'm going to start right here in the state of Maryland, specifically the Maryland shall issue versus Montgomery County, dealing with the notion of sensitive places and how Judge Chuang got this completely wrong. But frankly, I'm not surprised as an Obama appointee. But we're going to get to that in 1 second. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Disarmed: What the Ukraine War Teaches Americans About the Right to Bear Arms. Make sure you also follow me on Twitter at Four Boxes Diner. I'm now on there giving additional Second Amendment and constitutional information. Check it out there. All right, folks. So when I was gone doing my Supreme Court media routine, the United States District Court for the District of Maryland, Judge Theodore Chuang, issued an order rejecting the preliminary injunction request by Maryland shall issue and other plaintiffs, claiming that various quote-unquote sensitive places, which as you know are a euphemism for government-mandated gun-free zones, that Judge Chuang issued an order denying this motion for a preliminary injunction to enjoin these Montgomery County laws and instead said that they're perfectly constitutional under the Constitution. Yet one wonders what Constitution Judge Chuang was trying to interpret. We're going to talk about that in detail in 1 second. But to begin with, let me tell you what the issue was. Then we're going to talk about the standing issues presented and some ways to improve. And by the way, there's going to be some very practical advice I'm going to give to you if you're out there litigating Second Amendment cases involving the notion of standing, not just for Second Amendment cases, for other cases as well. And then we're going to talk about just how bad Judge Chuang screwed up the sensitive places analysis. But since he was a Barack Obama pick to the federal bench and also spent virtually his entire career working for the government, frankly, I wasn't surprised that this is the kind of outcome you would get from this kind of a judge. Remember, this is also the judge that was overturned 6-3 by the United States Supreme Court a few years ago in an abortion-related case for screwing that up. Again, we don't need to get into the details there, but Judge Chuang is known for getting reversed by the Supreme Court, so I'm not particularly shocked that he ruled against the Second Amendment plaintiffs in this case. Also keep in mind that the District of Maryland falls within the Fourth Circuit Court of Appeals, which is one of those courts overall that's terrible on the Second Amendment. So in light of all this, this is not a shocking decision from a practical point of view, but it's a wrong decision. So again, sometimes we have to learn from the mistakes of others so that other courts that perhaps are more earnest and serious about applying the Constitution as written don't make the same mistakes that others make, such as Judge Chuang. And we're going to discuss those right here and right now. So let's start off with the beginning. And this is I should note that, as all these cases are, they're very long. This is a 38-page long decision. I'll put a link to it down below. It takes a while to get through this and read the details and try to understand the wave of the hand, the way they sort of got through these arguments to get to the outcome. And I'm going to give you some of the details of this. But to begin with, this really turns on, again, places that Montgomery County says that even if you have been vetted and you have a concealed carry license for the state of Maryland, you still can't bring guns there. Now, what are some of these places? Well, to begin with, they include places along the lines of higher education, colleges, child care facilities, places of worship, libraries, parks, recreation facilities. There's a 100-yard buffer zone around these kinds of places, which is clearly unconstitutional. No basis in American law for that, at least at the time of the founding. And then to go on, they talk about places of public assemblies where you just have a group of people congregating. Basically, if you have a bunch of liberals congregating, then I guess conservatives can't exercise their Second Amendment rights because liberals want to exercise their First Amendment rights. That's not allowed, of course, but nevertheless, that's the kind of theory I think you're seeing out of Montgomery County. Other places that Montgomery County has labeled as a government-mandated gun-free zone includes things like publicly and privately owned parks, schools, recreation facilities, hospitals, polling places, courthouses, legislative assemblies, and any gathering of individuals to collectively express their constitutional right to protest or assemble. By the way, isn't it interesting as a side note that in the state of Maryland, which has Baltimore County, a crazy liberal place, Doesn't seem to do that well when it comes to the crime-ridden city of Baltimore, but I digress because Montgomery County, I don't believe, actually touches fingers directly with Baltimore, but it kind of just goes to the mindset. Now that we've covered the types of places that Montgomery County has labeled a sensitive place, gun-free zone, I want to talk about the issue of standing, and then we're going to get into the breakdown of the specific analysis of the sensitive places so you can take it with you, okay? To begin with, what is standing? Let me explain. I actually went over this about a month ago with Trey Gowdy on Fox News very quickly. The bottom line is that under Article 3 of the United States Constitution, a federal court only has jurisdiction to hear what are known as cases and controversies, or cases or controversies. Specifically, these are real cases with actual disputes between people that are literally fighting over a real-world issue that a decision by a federal court can resolve. They have to be actual real fights and not fake fights or hypotheticals or advisory opinions, anything like that. They have to be actual fights, because if they're not actual fights, then the federal courts, including the Supreme Court, lack the jurisdiction because you're not dealing with a case or controversy, and that is the touchstone for what federal courts can decide. Now, as a result of that, the plaintiffs, to show there's a real issue here, have to have what's known as standing, specifically that the actual plaintiffs that are suing have to be the ones directly impacted adversely by the government policy or law being challenged. So, for example, let's say I oppose the bombing of Cambodia for policy reasons. I am not allowed in the 1960s or the 1970s to go into federal court and argue that I don't want Cambodia bombed, because even though I have nothing to do with Cambodia, because that the court would say, Mark, it may or may not be right to bomb Cambodia for the federal government to do that, but you have no standing to bring this claim because you're not directly impacted by it, because you're not in Cambodia and you have nothing to do with it. You see, that's kind of the idea here. You have to be the one directly impacted adversely to be able to sue. Now, I want to put this into context, because one thing that Judge Juang did here is he rejected he actually said that the plaintiffs that brought this lawsuit, of which there's about 9 or 10 plaintiffs, lack standing to challenge very specific things involving sensitive places. He concluded that they did not have standing to sue over whether or not you could have a gun in public parks, whether or not you could have a gun in colleges or university grounds, whether or not you could have a gun in a hospital, I believe, and things along these lines. Now, all right. Practical point, practical teaching moment. If you're in a Second Amendment group in America today, and you are seeing on the horizon proposed legislation or rules or whatever it is in your jurisdiction of some anti-gun politicians are trying to create something as a sensitive place or whatever it is, you need to look down the road. It's not that hard. Specifically, before you bring a lawsuit and have plaintiffs say, I want to knock out these sensitive place laws on the grounds of Second Amendment, you want to make sure they have standing. Now, what Judge Juang here said is these plaintiffs failed to come forth with any evidence that they actually went to these college campuses in Montgomery County, that they went to these parks, that they went to these hospitals and these other related facilities. So what you should do, again, I'm not telling you to do anything that's false or to lie or commit fraud. I'm not doing anything like that. I'm just saying as a practical matter, if you want to build your record ahead of time, which you're allowed to build a record ahead of time, your potential plaintiffs should actually visit the places that you want to challenge and sue over. So, for example, if you are looking down the chessboard a couple months and you think you might have to sue over a sensitive place law that bans guns, let's say in a hospital, well, there's nothing wrong with finding plaintiffs that go to the hospital. Now, even if you're not sick, there may be other reasons to go to the hospital. For example, many of these hospitals have pharmacies that anyone can go into and buy stuff, medicine. So if you go to the hospital to buy your medicine, you keep a record of it, say, hey, I go to the hospital to buy my medicine from the pharmacy there, or perhaps you eat lunch in the cafeteria. Virtually all major hospitals have some form of cafeteria that serves food, and there's nothing that prevents an ordinary person from going to the hospital and having lunch there periodically. But any of these things would allow a potential plaintiff down the road to be able to, when they sue, to say, look, I go to the hospital to have lunch every now and then. Here's some of my receipts. I go to the hospital to go to the pharmacy or whatever it is. Likewise, if you're suing universities, remember a lot of these universities are open to the public. You can go there, you can sit on a bench, you can watch a football game, you can go to the library, and even if you can't check out books from the university library, it's often the case that you're allowed into the library to do research. So maybe you go in there before you bring the lawsuit to do some historical research or look at some books or whatever it is, so that when you bring the lawsuit as a plaintiff, you're able to honestly say that I actually use these facilities. I go to these colleges, I go to these hospitals, I go to these public parks and feed the pigeons, whatever it is. You build your record so that when the anti-gunners come back and argue you lack standing because there's no evidence that your plaintiffs have gone to the park, have gone to the college, have gone to the hospital, have gone to the nursing home, whatever it is, you're able to rebut by saying, no, it's not true. Here are the examples in just the last few months alone where I've gone to these sensitive places, and I would like to be able to bring my gun there for safety, but I'm not allowed to. So, because what happened here with Judge Chuang is he specifically said there's no evidence that any of these plaintiffs go to these places, therefore I'm not even going to get to the Second Amendment question because they lack standing. So again, practical teaching point I'm now conveying. Give that some thought. Obviously, you want to do it in conjunction with the lawyers and all that, but you get the concept of what I'm trying to convey here, and hopefully that's helpful. Now, with that said, Judge Chuang did find standing by these plaintiffs to challenge certain of these quote-unquote sensitive places. Judge Chuang did find that the plaintiffs had standing to challenge certain sensitive places, specifically on page 15 of his opinion. He said the court therefore finds standing as to the Second Amendment claims relating to the prohibitions on carrying a firearm at a private school, a child care facility, a place of worship, a public park, a recreational facility, or multi-purpose exhibition facility, a public library, and within 100 yards of any place of public assembly. But he goes on to say, I do not find standing as to the claims relating to the rest of the identified locations. Again, if you're going to bring these lawsuits, come up with a checklist, write down the places you want to challenge, and make sure your plaintiffs visit these for some purpose before you bring the lawsuit, or at least during the lawsuit, so when you're asked, the plaintiffs can honestly say that they go to these facilities or they go to these locations for some particular reason, and that will help give you standing so you can challenge these claims. Because if you lack standing, it's not just Judge Chuang that can't rule on it. The U.S. Supreme Court can't rule on it either, because they're denied jurisdiction if there's no standing by the plaintiff, because if there's no standing by the plaintiff, it's no case or controversy, and under Article 3 of the Constitution, they can't hear the case. Now, in analyzing Judge Chuang's decision specifically on sensitive places, it's clearly wrong. And I'm going to go through the high-level obvious problems, and then maybe we'll talk about some of the specific mistakes he made. But at the highest level, the most obvious mistake is he did not do the work. And what do I mean by that? He simply assumed, for the sake of argument, that the dicta, as we've talked about on this channel before, when your court order tells people what to do. It's the order. You have to go to prison. You have to stay off my lawn. You cannot enforce this law. That is the order. Courts will then write an opinion explaining why they reached the conclusions they reached and why they issued the order they did. So the order is the legal document that tells you to do something or not to do something. The court's opinion explains the reason why they achieved or reached the conclusion that finds its memorialization in the order. So that's why we talk about Supreme Court opinions laying out the rationale for all sorts of things. And when you look at the Supreme Court opinions, they have two parts to them. At a minimum, a holding, which is the specific rule. Now, the Heller case held that we have an individual right to have a loaded, unlocked handgun in our homes for the purposes of self-defense under the Second Amendment. That's the basic holding. But it had a lot of what's known as dicta. Now, dicta is the parts of the opinion that lays out a lot of analysis and whatnot, but it's not necessarily the holding. So the dicta is very persuasive, but it's not necessarily the holding. So for example, and this is what's so important, that Judge Chuang failed to distinguish between. In the Bruen case, there's a lot of discussion, as you know, about how to apply the Heller text first and then historical analog analysis second. Heller did that analysis first. The court screwed it up for 10 years, and then Bruen basically was issued to try to teach the lower courts how to apply Heller correctly. So although it's called the Bruen methodology, it's really the Heller methodology where the Bruen methodology is labeled as such, but it's really just doing what Heller did, except they're basically saying, hey, you lower courts, paint this by numbers. Stop screwing this up. We're going to lay it out for you in easy to understand terms so even you guys can't screw it up. At least that's what the Supreme Court was hoping, but obviously that's not happening. Now, I mentioned this to you because in Heller and Bruen, there is a discussion about how to apply historical analogs and analyze future Second Amendment cases. This was not concluding or answering the questions. It just explained the methodology, and especially with respect to sensitive places. But what Judge Juang did here, and I think was a mistake, is he assumed that some of the dicta in Heller and Bruen about sensitive places was actually the law of the land and failed to do any of the actual analysis he's required to do. So, for example, here you have the Supreme Court talking about sensitive places, saying that, in Bruen at least, that there was very few places where weapons were altogether prohibited, specifically legislative assemblies, polling places, and courthouses. Okay? There was also a passing reference, also in dicta, which means not part of the holding, the essential part of the case, in Heller that just says, this decision in Heller is not alone basis for knocking out any laws forbidding the carrying of firearms in sensitive places such as schools or government buildings. But this was all dicta. They're laying this out as a possible presumptive law, but not necessarily binding law. For example, if you look at what Bruen says, and this is key, quote, this is after they discuss the sensitive places involving the legislative assemblies, polling places, and courthouses. It goes on to say, quote, we, that's the Supreme Court, we therefore can assume it is settled that these locations were sensitive places where arms carrying could be prohibited consistent with the Second Amendment, and courts can use analogies to those historical regulations of sensitive places to determine that modern regulations prohibiting the carrying of firearms in new and analogous sensitive places are constitutionally permissible. But it goes on to, of course, point out, although in Bruen and Heller, those cases did not involve sensitive places, they were trying to use the sensitive places notion as a teaching tool for how to deal with future cases. But they hadn't actually decided these things, which means that lower court judges, like Judge Juang, have to actually do the analysis and understand what makes arguably a polling place a legislative assembly or a courthouse a sensitive place. What is the essence of these things that allow them on certain occasions to be a gun-free zone? But if you don't do the analysis of why those are sensitive places, by definition, you're not able to use those and extend that to other sensitive places, right? Because you can only compare A to B by first understanding the essential characteristics of what is A, right? What makes A an A? Or for example, if you're a phenomenologist, which means you are studying, among other things, the essence of things, what makes a chair and not a stool and not a couch? What makes a chair a chair? What makes a stool? What makes a couch? And how are they similar and how are they different? Because they're obviously different. That's why you have a chair, a stool, and a couch. So again, when you're dealing with sensitive places, you have to first understand the essential characteristics of the sensitive place, of these polling places, assembly, legislative assemblies, and courthouses. And the one common denominator they all have is, of course, they all had a form of comprehensive security. Legislative bodies had sergeants at arms to protect the legislatures in those legislative assemblies when they met. Courthouses had armed bailiffs when they met. And polling places also had, various forms of comprehensive security. And they were also very limited because remember, polling places don't go on 24/7, 365 days a year. Polling places only exist, at least back before we had multi-month elections, set that issue aside, but polling places only exist for a day, a limited period of time, in a finite number of locations, and that was it. That was it. But none of this analysis appears in anything that Judge Juang says. He just takes it as an assumption that these are indeed sensitive places. He never analyzes them. And then from there, he just starts saying, well, everything is analogous to these three things. And therefore, all these places, of which I've listed earlier, are allowed to be sensitive places you can ban guns. Now, but here is how he does it. How is he able to do it? In addition to the fact that he doesn't even try to identify the essential characteristics of these three places. He makes reference to government buildings, but as you know, Heller just generally talked about government buildings and schools, but then they narrowed it down to three specific places in Bruen, a little bit more precise. And basically what all anti-gunners are doing today, including Judge Juang, is essentially labeled to say, oh, there's 5 places that are sensitive: schools, government buildings, and polling places, legislative assemblies, and courthouses. Anything that's like those 5 things, we can ban guns, ignoring all sorts of other language from Heller and Bruen that says that's not true. Nevertheless, that's what he did. But the real mistake that Judge Juang makes, which is just absurd, is he says specifically, and here's what's interesting. He specifically says that he does not need to use the year of our Lord 1791 to interpret the Second Amendment. That he is allowed to use the year, as I predicted. I told you this is going to happen, but don't worry, I've blown it up. I told you the anti-gunners were desperate to try to make the late 19th century their relevant time period because you had a lot more gun control laws in the late 19th century. A lot of it because you had black codes and Jim Crow laws that were designed to harass blacks in the South. So you got a lot more gun control law in the late 19th century. Also, you're coming out of a period of civil unrest with the Civil War. So the anti-gunners are desperate to try to make the adoption of the 14th Amendment in 1868 the key time period for adopting and restricting our Second Amendment rights. They don't want it to be 1791 when the Bill of Rights was adopted and ratified and it went into effect, because that's when the Second Amendment was. There was a lot fewer gun control laws in 1791 than in 1868. And of course, Judge Juang, who went to Harvard undergrad and Harvard Law School, obviously immediately jumps on this. And here's how he does this little sleight of hand here. Doesn't do any serious analysis. He just quotes part of the Supreme Court opinion that says, well, the Supreme Court acknowledged that there is a quote unquote ongoing scholarly debate on whether courts should primarily rely on the prevailing understanding of the individual right when the 14th Amendment was ratified in 1868 when defining its scope as opposed to 1791. So what Judge Juang does is he quotes this language about a head nod to academics that are debating this question, but what he fails to do, of course, is to actually look at what's binding on him as an inferior court, a lower court under Article 3, which is Supreme Court precedent. Because if we were to look at the Supreme Court precedent, it's a no-brainer. You have to apply 1791. To begin with, the Supreme Court says right up front in Bruen and in Heller, quote, constitutional rights are enshrined with the scope they were understood to have when the people adopted them. When was the Second Amendment adopted? 1791. What did the 14th Amendment do in 1868? It did not rewrite the Second Amendment. All the 14th Amendment did was say that going forward, the states are also bound by the terms of the Second Amendment as understood in 1791, and the free African American slaves are also protected by the Bill of Rights. That's all the 14th Amendment did when it comes to our Bill of Rights. It didn't redefine the Bill of Rights. It simply, again, applied them to new people, and that's what they did. Now, don't take my word for it. Take the word of the Supreme Court. Specifically, the Heller Court, remember, looked to the mid-19th century history only as, quote, mere confirmation of what the court thought had already been established. As you and I have talked about, late 19th century historical evidence can be relevant, but only as it confirms the understanding of 1791. Any history from the late 19th century, all of which is Judge Juang literally just assumed, for the sake of argument, the late 19th century historical gun control laws, allows him to ignore the plain text and the understanding of the 1791 Second Amendment. And he just went to town, quoting all these laws from the South in the late 19th century, which is what I predicted the anti-gunners want to do, but they can't do that if they want to be honest and consistent with Supreme Court precedent. Because again, the only time the 19th century is relevant is to confirm the 1791 understanding of the Bill of Rights, including the Second Amendment. Now let us continue. In Bruen, and this is the thing that Judge Juang conveniently ignored, this is what Bruen said. This is not Mark Smith. This is the Supreme Court in Bruen. Quote, strictly speaking, New York is bound to respect the right to keep and bear arms because of the 14th Amendment. Well, that's true, because the 1791 originally just applied to the federal government. The 14th Amendment allowed it to apply to the rest of the states as with respect to the rest of the Bill of Rights. But the Bill of Rights, as understood in 1791, when it was adopted by the people in 1791. Again, the Supreme Court goes on in Bruen to say, nevertheless, we have made clear, that's the Supreme Court, we have made clear that the individual rights enumerated in the Bill of Rights and made applicable against the states through the 14th Amendment have the same scope as against the federal government as against the states. And we have generally assumed that the scope of the protection applicable to the federal government and states is pegged to the public understanding of the right when the Bill of Rights was adopted in 1791. Close quote. Who said that? The United States Supreme Court in 2022 in Bruen said that. They talked about the 14th Amendment and the Second Amendment and said the understanding is pegged, quote, when the Bill of Rights was adopted in 1791. Now, strangely enough, that language does not appear in Judge Chuang's decision here in Maryland shall issue. Strange, right? But let us continue. They then go on to say, they do say this. They say, we acknowledge that there's an ongoing scholarly debate. They acknowledge it, but this is just saying, we're aware of it. But so what? We don't care. That's not what we do. Because again, you cannot have two separate understandings of the Second Amendment. One as applies to the federal government in 1791, and a different understanding that applies to the states in 1868. That is never how the Supreme Court interprets the Bill of Rights in any context. Now, what else did the Supreme Court say about this notion that Judge Chuang embraces dealing with the late 19th century? Well, the Bruen Court acknowledged specifically there is an uptick in Western territories, not states, territories, in the late 19th century. That's what they referenced. Bruen was aware of it. And what did they say about it, though? What did the Supreme Court say about it that Judge Chuang has to follow? This is what they said. Quote, as we suggested in Heller, late 19th century evidence cannot provide much insight into the meaning of the Second Amendment when it contradicts earlier evidence, period, close quote. Not me, that's the Supreme Court. When the late 19th century evidence contradicts the Second Amendment's earlier evidence from 1791, you go with 1791 because that's when it was adopted. Now, to further destroy this argument that Judge Chuang talked about in his decision, the Supreme Court also points out in Bruen, quote, we have made clear that the individual rights enumerated in the Bill of Rights and made applicable against the states through the 14th Amendment have the same scope as against the federal government, which means the 1791 application applies to the federal government, has to be the same understanding that applies to the states. That's what the Bruen Supreme Court said. And then the Supreme Court goes on to say, this is what they reference in McDonald and beyond, in other Second Amendment cases, they say, the Supreme Court has, quote, abandoned, and speaks literally directly to Judge Chuang here. The Supreme Court has, quote, abandoned the notion that the 14th Amendment applies to the states, only a watered-down, subjective version of the individual guarantees of the Bill of Rights. And that is exactly what the mistake that Judge Chuang was making here. He's trying to apply a watered-down version of the Second Amendment by quoting the 14th Amendment to sneak around it, but that's already been anticipated by the Supreme Court and slapped away and said, no, no, no. Not me, the Supreme Court itself. Because again, the Second Amendment is understood when it was adopted in 1791. Now, by the way, this is what the Supreme Court always does in all other aspects of interpreting the Bill of Rights. So, for example, in a case called McIntyre, where they're talking about the free press, the First Amendment, again, this is Clarence Thomas. Quote, when interpreting the free speech and press clauses of the First Amendment, we, the Supreme Court, must be guided by their original meaning, for the Constitution is a written instrument. As such, its meaning does not alter. That which it meant when adopted, it means now. And when was the Second Amendment adopted? 1791. Now, to continue on, and I'm just going to sum this up, because obviously the mistakes are so obvious here. And I'll put a link to my article in the Harvard Journal of Law and Public Policy that you will find interesting. In the other major cases involving the Bill of Rights, I'll just give you three, because when they talk about this at Bruen, they cite to three cases, a case called Crawford versus Washington, a case called Virginia versus Moore, and a case called Nevada Commission of Ethics versus Kerrigan. In all three of these cases, They dealt with the application of the Bill of Rights to the states through the 14th Amendment. And in all of these cases, guess what? They all used the 1791 understanding of the Bill of Rights to apply to the states, despite the fact that the mechanism to apply the Bill of Rights to the states is the 14th Amendment. Did Judge Chuang consider any of this? Did he read any of the opinions or the court cases that the Supreme Court cited to tell him what to do as an inferior court? Obviously not. Obviously not. And I'm going to tell you why. Now, I'm sure Judge Chuang is a perfectly smart guy, but I have to say this. Here's the reality of it. There's an old saying that the gun should serve the party. And what I mean by that, it's a classic rule of modern-day liberalism and progressivism, and Marxism for that matter, that guns are fine to protect the government and government agents and government employees, the state, if you will. Nothing wrong with guns as long as they protect the right people. But again, as you know, the anti-gunners don't want you and I and American citizens to have the guns. They just want the government to have the guns. They like guns for themselves, just not for us. Because if they can take the guns from Americans, we no longer become citizens. We are simply serfs or subjects or worse. So never lose sight of this. And keep in mind that every day we have our gun rights and every day we can buy guns and ammunition is a good day for American freedom. Okay, folks, I know this is a long video, and I'm sorry it took me a while to get to this Maryland case, but it was a big deal, and I want to talk a little bit about it. I may even do more on it down the road. But again, if you haven't subscribed to the Four Boxes Diner, please do so. We'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.